I am here on the floor to ask for some courtesy for a pair of nominees. These are nominees to the Court of Federal Claims, which is the court to which citizens can come with claims against the federal government. In the Court of Federal Claims, the federal government is the defendant. And these two individuals are in an enormous traffic jam that our colleagues have created for nominees. At the moment, I'm told we have 159 nominees out of committee, on the executive calendar, backed up on the Senate floor. 159. I'm on the Judiciary Committee. These two are judges. They're for the Court of Federal Claims. This is not a partisan thing. This is about letting the Court of Federal Claims do its work. Both of them are extremely well qualified. Neither is partisan. Both were voice voted out of the Judiciary Committee. And I would hope, just as a matter of courtesy and common decency, we could agree tonight to move them forward. One of them is named Armando Bonilla. He served as the counsel to the Marshal's Service. He served as counsel to the Deputy Attorney General. He served actually as Associate Deputy Attorney General. In the Department of Justice, it's not an easy thing to move up from being counsel to the Marshal Service to being counsel to the DAG to being Associate DAG. So that's a pretty impressive record. Before that, as a trial attorney, he had served in the Public Integrity section of the department, in the asset forfeiture and money laundering section, bringing those cases, and in the civil side, in the commercial litigation division. So he's got the trial qualifications you would want. He's got the experience from the government side that you would want. He's got a voice vote out of committee. And if that's not enough, he's a graduate of West Virginia University. So he's a, I think, very well-rounded individual who would serve well in the Court of Federal Claims. Also, I'll be asking to confirm Carolyn Lerner, who brings her own superb qualifications to this position as well. She's right now the Chief Circuit Mediator for the Court of Appeals for the D.C. Circuit. So she deals with litigation conflicts all the time. She's obviously viewed with considerable regard by the court to have made her their Chief Circuit Mediator. She served for many years in private practice, so she'd be very familiar with the private practice of the individuals that come before the Court of Federal Claims. Again, private person versus federal government is what that court's business is. And she even taught law. So Carolyn Lerner and Armando Bonilla are both very well qualified, and both came out of the Judiciary Committee with voice votes, which means they both had bipartisan support. And this is an important court to proceed with. Now, what's happened here, and the reason we're now up to 159 backed up nominees for executive and judicial positions, is that our colleagues on the other side are insisting on cloture for essentially almost every individual who comes through, and that eats up time on the Senate floor and slows things down and creates the traffic jam. It's like you're driving on Highway 95 and you pull into the middle lane and drive at 25 miles an hour. You are going to jam up traffic behind you. And that's what our friends are doing. They're jamming up traffic. I think there's certainly members of the other party who would like to see the Biden administration not be able to get its team in place just for partisan reasons. So when Donald Trump came in his first year, he was obviously not popular with us on our side, and he had some pretty appalling appointments. But even in that very hostile environment, the Republican leader only had to file cloture for 65 appointees. 65 in that first year. We're in President Biden's first year, we're already at 127. So the cloture rate has doubled from even that very difficult, challenging year when Trump first came in. And I see my friend from Alaska here, so I'll just review the bidding. We've got 159 nominees backed up on the Senate floor who are all out of committee, all ready for votes, many of whom are coming out of committee with voice votes or big bipartisan majorities. Two of them are the individuals who I'm going to be asking unanimous consent to confirm tonight, Armando Bonilla and Carolyn Lerner. My friend from Alaska served in the Department of Justice, so he knows that it ain't nothing to be counsel to the Marshal Service and then counsel to the DAG and then associate DAG. That's a really impressive climb through the top ranks of the department, and that to have served as a trial attorney in the public integrity section and in the fraud, money laundering, asset forfeiture, money laundering section, and on the civil side in complex commercial litigation. That's a very impressive resume. Ditto Ms. Lerner, who has been chosen to be the Chief Circuit Mediator for the D.C. Circuit Court of Appeals. That's a pretty impressive credential all on its own. So what I would like to do in order to get these two through the traffic jam and onto the Court of Federal Claims, where their presence is needed, is to ask unanimous consent that the Senate proceed to executive session to consider their nominations, which are executive calendar numbers 489 and 490, and further that the nominations be confirmed, that the motions to reconsider be considered made and laid upon the table with no intervening action or debate, that no further motions be in order to the nominations, that any related statements be printed in the record, that the President be immediately notified of the Senate's action, and that the Senate then resume legislative session.
Is there objection?
Mr. President.
Senator from Alaska.
Reserving the right to object. Mr. President, I've worked very closely with my colleague from Rhode Island on many issues, and there's a pretty simple solution for my objection here, and it's related to judges, and it's related to the Senate working with the White House to get judges confirmed. I gave a speech on the Senate floor just about an hour ago, Mr. President, talking about a remarkable breach of Senate protocol where the White House won't let certain senators from the Court of Appeals of the Ninth Circuit states to meet with the nominees for the Court of Appeals for the Ninth Circuit. Mr. President, that's an outrage. In my entire time in the U.S. Senate, every time I've requested to meet with a judge who's going for confirmation to the United States Court of Appeals for the Ninth Circuit, I've had the opportunity to meet with that judge. And it's really important. I'm not going to repeat the arguments I made just an hour ago, but there's a simple solution here. We get to meet with the nominees that we're debating on the Senate floor this week, and I certainly will lift the objection that I'm about to make on these two nominees for the Court of Federal Claims. But I do want to just push back on my good friend from Rhode Island a little bit. My colleagues on the other side of the aisle forced votes on the Court of Federal Claims nominees during the Trump administration, including Judge Sullivan, who literally wrote the book on the Court of Federal Claims. So here's the thing. What often happens in the Senate, what goes around comes around. But what's happened today, Mr. President, when I was requesting what I've always been requesting, what my constituents in Alaska expect me to do, is to interview, meet, discuss issues with the judge who's going to get life tenure that's going to have enormous power over my constituents, Ninth Circuit Court of Appeals judges. I don't know anybody who has heard that the White House counsel says, no, you're a senator doing advice and consent, constitutional duty, and we are forbidding you to meet with a judge going through the confirmation process who's going to have enormous power over your constituents. That's unheard of since I've been here. And by the way, I talked to the Trump administration, White House counsel. They said they never did that. But here's the point. This could be easily solved. I'm sure Mr. Bonillo, Ms. Lerner are qualified. All I need is a call from the White House counsel's office saying, you know what, Senator, you can meet with the nominees for the U.S. Court of Appeals for the Ninth Circuit. We're going to let you do your constitutional duty. Well, I thank you. Pretty simple. And I think working closely with my colleague from Rhode Island, as I've done throughout my career, and he's on the Judiciary Committee, so maybe he can help convince the White House to take a bit of a different stand when a senator wants to meet with a judge who's going to have enormous power over his constituents and have lifetime tenure, and they can't take an hour out of their time. Heck, on my speech just an hour ago, I put out my office's phone number and said to these judges, look, you don't have to get permission from the White House counsel. Just call me. Let's have a discussion. I'm trying to do my constitutional duty here. So with that, Mr. President, I object.
Objection is heard.
Mr. President.
Senator from Rhode Island.
In the spirit of what goes around comes around, let me just say that the First Circuit is a good deal smaller than the Ninth Circuit. My state of Rhode Island is in the First Circuit. We didn't have many vacancies during the Trump administration on the First Circuit. The only one we had was not filled. But I'm not aware of any member on our side being offered to meet with any Trump judicial nominee at the circuit court level. And indeed, those of us who are on the Judiciary Committee didn't even get our 5 or 7 minutes of time in the hearing with Trump circuit court nominees, because the Trump administration worked out some kind of a deal that their nominees could be put on the same panel, something that had only been done before with the agreement of both parties. So they would bring in their circuit court nominees, and you still got your 5 minutes or your 7 minutes, but now there are 2 or 3 on the panel. You get like 1 minute each. So I just have to say, I like my friend from Alaska, and we do work well together, but when I couldn't get 5 or 7 minutes in the committee, in the hearing with a circuit court nominee, it's hard for me to feel a great sense of outrage that somebody not on the committee doesn't get a special private meeting with judges. We never got special private meetings with judges. We didn't even get our time with the judges in the hearing because they sandwiched a bunch of them onto the same panel in our same 5 to 7 minutes. So what I would like to do is to propose, since the objection has been made to confirming them tonight, that at least we might consider moving through the cloture step so that a vote can be scheduled and that everybody can have their vote one way or the other. So my first unanimous consent request would have confirmed them. And a call could have gone out to them and to their families tonight saying, the holds are off, your life is back in order, you can go to the job you've been nominated for, and all would have been well. There's been objection to that. So what I would like to do is simply ask that they be allowed to tee up for a vote when scheduled without having to pursue the cloture path. And so I ask unanimous consent that notwithstanding Rule 22, if applicable, at a time to be determined by the majority leader in consultation with the Republican leader, the Senate proceed to executive session to consider the following nominations. Again, it's executive calendars number 489 and 490, and that there be 10 minutes for debate equally divided in the usual form on the nominations en bloc, that upon the use or yielding back of time, the Senate proceed to vote without intervening action or debate on the nominations in the order listed, that if a nomination is confirmed, the motion to reconsider be considered made and laid upon the table with no intervening action or debate, that no further motions be in order regarding the nominations, and that the President be immediately notified of the Senate's action. Again, this would not confirm them tonight. Their families will not get this call that they are freed from our little executive calendar traffic jam, but it would at least put them on a pathway towards confirmation.
Is there objection?
Mr. President.
The senator from Alaska.
Reserving the right to object. Mr. President, I have a simpler solution here, as I already mentioned it. The White House has denied my ability to meet with one Ninth Circuit judge who just got confirmed. But let me meet with the next two, and then will you see these nominees that Senator Whitehouse has been trying to move forward tonight? And I also want to mention to my colleague from Rhode Island that I'm certainly more than amenable to work with him on a principle that I think all senators should agree on, all of us, to strengthen this institution, whether you're Democrat, Republican, and that's this simple idea, which I thought existed here, because I've certainly been able to do it. If a judge is up for confirmation, a circuit judge, and you are a senator representing one of the states in the circuit, and that judge is going to have enormous power over your constituents for life, that we should, as a general rule, a general principle, say always, of course you get to meet with that judge. Of course you can do your constitutional advice and consent duty. I'd be for it, for any Democrat who wants it, if there was a Republican. And again, I talked to some folks from the Trump administration today. They said that they always offered that. So maybe there's a misunderstanding. I don't want to say that my Senate colleague from Rhode Island is not right, or those guys. I don't know. That's what they mentioned me. But I just think as a principle, every senator here should agree with that. Why wouldn't you want to do that? Like I said, until today, I met with every single Ninth Circuit judge that we voted on in my entire career here. Now, it's been a relatively short career, but this is really important to the people I represent, because that court is really important to the people I represent. And the Ninth Circuit so frequently gets the law wrong as it relates to Alaska and negatively impacts my constituents. So this is important. So I object to this date certain request, but as I mentioned, if I can meet with these two more Ninth Circuit judges, Senator Whitehouse can come down here and you see these two Federal Court of Claims judges, and I think he can move. It's a real simple ask. And the fact that the White House counsel doesn't even call me back, U.S. Senator trying to do our constitutional duty, advice and consent of the Senate. The senator from Rhode Island and I are of the Senate. So why don't we work on this principle that if there's a nominee, a circuit judge nominee, and a senator from a state in that circuit wants to meet with that nominee to do his constitutional duty, that we should all agree to do that, no matter who's in the White House. I would agree to that principle in a heartbeat.
Objection is heard.
Well, I think we've
Senator from Rhode Island.
concluded this matter for the evening, and I'm very sorry that it has ended this way because Mr. Bonilla and Ms. Lerner are essentially collateral damage in a fight that does not involve the Court of Federal Claims at all. This involves a dispute between the Senator from Alaska and the White House, who I do not direct and who I do not speak for. And instead of keeping it within the confines of the Ninth Circuit, it is now spilled over to the Court of Federal Claims, and these two completely unrelated individuals are continuing to have their lives interfered with by being kept in the traffic jam for a principle that, in my view, was never followed in the previous administration. I mean, for Pete's sake, if they're not even going to let us have our official time with a circuit court judge, the idea that we were going to get private meetings is, I think, imaginative in the extreme. And I just regret that it has come to this pass. I regret that we're at 159 obstructed nominees backed up. I regret that we've been forced to file cloture twice as much as that first group of Trump nominees in his first year, and there were some real beauties there, I got to tell you. So with that, I just will yield the floor, and pardon me while I go to the front to get the script to close out the Senate.